I welcome you all to another guest lecture of the Judges Guest Lecture series of the Global South Network that I've been leading and running since March 2023. I'm Dr. Nauman Rayat, the founder and convener of the Global South Network and the organizer and moderator of today's guest lecture. I'm a lecturer in law at the Leicester Law School, University of Leicester. My research interests include, but are not limited to, judicial independence, rule of law, judicialization of politics, and constitutionalism in the Global South. I established Global South Network on 17th March 2023. It consists of academics, including staff and students from different schools and colleges of universities across the globe, and actors outside academia. It is aimed at empowering people from or focusing on the Global South. Currently, there are different groups or organizations with the title including the word the Global South, situated in different parts of the world. However, as of today, the Global South Network that I'm leading is the only international interdisciplinary network that organized around 70 knowledge exchange activities, including 4 international hybrid conferences, around 60 online PhD in progress weekly seminars, 12 guest lectures of Supreme Court judges from different countries, created a team of conveners, established an interdisciplinary advisory committee, and launched Network's mentoring initiative, completed 2 edited collections on judicial independence, and created opportunities of public engagement for academics from all backgrounds just over a year of the network's launch. The social, political, economic, and legal issues of the Global South received due attention during these activities. Recently, I received queries regarding how the Global South Network could include countries that are not usually included in the Global South by international organizations and some scholars in its activities. Please allow me to clarify that for the Global South Network, the concept of Global South consists of all those features that have been discussed by various international organizations and the scholars focusing on the Global South. I can understand that there are different names used for the Global South, including but not limited to developing countries, majority world, unstable democracies. But for the Global South Network, it is also the idea of empowering people from or focusing on the Global South through knowledge exchange and sharing good practices on various issues of the Global South and contributing to bridging social, religious, political, legal, economic, and ideological gaps between North and South. Currently, the world in general and the Global South in particular is passing through very delicate time. On the one side, we have conflict between Israel and Palestine in the Middle East. And on the other side, we have conflicts in Afghanistan, Central Asia, and between Ukraine and Russia. The role of law, courts, and judges is very important in creating an environment of peace. In this regard, I'm honored to lead and run the world's only network that made an unparalleled contribution to equality, diversity, and inclusion by hosting the guest talk of judges of both Supreme Constitutional Court of Palestine and the Supreme Court of Israel during the peak of the Middle East crisis. Today, I'm honored to have Judge Doctor of Law, Professor Vitaliy Urkevych, Secretary of the Grand Chamber of the Supreme Court of Ukraine, as guest speaker during the Global South Network Judges Guest Lecture Series. Judge Doctor of Law, Professor Vitaliy Urkevych is Secretary Grand Chamber of the Supreme Court of Ukraine since 2023 and Judge the Supreme Court Commercial Session Court Ukraine since 2017. Previously, he was Judge Grand Chamber of the Supreme Court of Ukraine from 2017 to 2020. He completed his PhD at Yaroslav Mudry National Law University, Ukraine in 2007 and was an associate professor at the Department of Agrarian Law, Yaroslav Mudry National Law University, Ukraine from 2007 to 2017. Now I invite our guest speaker, Honorable Judge Doctor of Law, Professor Vitaliy Urkevych, Secretary of the Grand Chamber of the Supreme Court of Ukraine, to deliver his lecture titled Ukraine Supreme Court's practice in cases related to the war in Ukraine. Over to you, Honorable Judge Vitaliy Urkevych.
Good afternoon, dear Dr. Manriat. Good afternoon, dear colleagues. It's a great pleasure to me to deliver this lecture to your attention, and I hope that it will be interesting and useful for lawyers. I have to start with information that the invasion of Russian Federation in the territory of Ukraine began at the end of February 2014. I mean, annexation of Crimea, occupation of parts of Donetsk and Luhansk oblasts, and then full-scale invasion launched by the aggressor state on February 24, 2022, when at 5 a.m. the offensive began from several directions. I mean, northern Kyivska, Sumskaya, Chernigivska oblasts, eastern Donetsk, Luhansk and Kharkiv oblast, and southern from the occupied Crimea to Kherson, Mykolaiv, Zaporizhia and Mariupol, and you can see on the slide these directions. It's absolutely obviously that the goal of the Kremlin is the military destruction of Ukraine's state and its national identity. The war affected every Ukrainian, all areas of our life, I mean the economy and labor market, social relations, marital and family relations, caused a wave of internal and external migration. Above 5 million citizens of Ukraine received temporary protection in Europe countries. Some of them are in the United Kingdom, and we have such figures that property damage caused by Russian Federation as a result of hostilities to the population and businesses is estimated at 500 billion euros. The damage to the environment is about 55 billion euros. Military operations also affect the functioning of the judicial system of Ukraine, constant air alerts, lack of energy supplies, dismissal of judges due to professional burnout and constant stress, shortage of court staff as a result of recruitment to the armed forces of Ukraine, migration, destruction of courts' premises by rocket fire, courts falling under occupation, capture of judges, are factors that have a negative impact to the administration of justice. In this slide, you can see a picture of the premises of the commercial court of Mykolaievska Oblast. It was hit at the beginning of 2022 in the morning during the start of the working day. At the same time, new categories of cases appeared during the war in which the most complex legal problems arose. And so, I must say that Supreme Court formulated a number of important legal opinions in cases related to a war in Ukraine, among which the following can be named in particular. First of all, regarding the person liable for committing the crime of planning, preparing, unleashing, invading an aggressive war. You can see the legal opinion that such persons must have the relevant power, resources in the field of international relations, domestic politics, defense, industry, economy, or special social positions that allow them to influence on adoption some decisions. These persons can outline the general course of state development, implement it, represent state in international relations, influence its rulemaking activity, form state policy, and so on and so forth. And among this person are heads of states and governments, members of parliament, leaders of political parties, diplomats, heads of special services, and other persons. And all of this you can find in judgment of this Grand Chamber of the Supreme Court on February 28, 2024, in cases which number you can see at this slide. Actually, further in the next slides, also some judgments of the Supreme Court will be mentioned. Also, I have to say that the next legal opinion regards to the procedure of receiving compensation for forcibly expropriated or mobilized property in the condition of the regime legal or martial time. According to the legal opinion of the Supreme Court, such compensations for material and moral damage caused to the state of Ukraine, legal entities, public associations, citizens of Ukraine, other persons fully relies on the Russian Federation as the occupying state. I also have to mention about the legal opinion of the Supreme Court regarding the establishment of the fact of living in the same family without marriage with a deceased military serviceman for the purpose of receiving monetary payments. A lot of cases are heard by national courts now, and so the Supreme Court established that cases establishing such a fact are subject to consideration in civil proceeding, regardless of the purpose of the appeal to the court, in particular confirmation of social status for the appointment and payment of a one-time cash benefit to the family of such the military serviceman. Next legal opinion of Supreme Court regards the impossibility to suspending the proceeding in the case due to the plaintiff's stay in the armed forces of Ukraine if he insists on continuing the proceedings. After all, the proceedings in the case, in accordance with our procedural legislation, so the proceedings are subject to suspension only in the event of the existence of circumstances that prevent its consideration. The plaintiff, who has been called up to the military service, the plaintiff in this case, took an active part in the proceedings and also insisted on the completion of the proceedings. And that is why the Supreme Court held that actions of the defendant who requests to suspend the proceedings in this case of appellate review of the judgment adopted not in his favor do not correspond to the principle of good faith. Let's go further, and important legal opinion were made by the Supreme Court in cases about determination of the child place of the residence and the return of children who left abroad after the beginning of the full-scale invasion of Russia. Based on the results of considering such disputes, the Supreme Court formed its ruling regarding, first of all, the possibility of resolution of a dispute on the determination of a child's residence place who is abroad by Ukrainian courts. Also, the security for a claim on the determination of a child's residence place who has moved abroad with one of the parents by ensuring communication with the child by means of telephone and internet communication. And also regarding the possibility of filing a claim on the removal of the child's and his or her return to the previous place of residence in the event that one of the parents does not comply with the judgment on determining the child's residence place with the other parents. In fact, during the first months after the start of the full-scale invasion, the Supreme Court ruled in the important legal position regarding the judicial immunity of the aggressor state. For the first time, this legal opinion was formulated by the Civil Cassation Court. It's a judgment of April 14, 2022, and further in range of judgment of the Supreme Court, this legal position was developed. I will outline this issue in more details. In this case, the plaintiff, acting in her own interests and on behalf of minor children, appealed to the court with a lawsuit against the Russian Federation for the compensation for moral damage caused to her and her children as a result of the death of her husband and father of her children because of the armed aggression of the Russian Federation. The court of the first instance rejected the claim. The appellate court issued a ruling to send to the embassy of the Russian Federation in Ukraine a request for consent or non-consent on consideration of the civil case by a Ukrainian court. Also, the appellate court sent a copy of appeal and ruling to open the proceedings and also suspend the proceedings until the response of the embassy. The court did not receive any answer. So, having considered the case in the cassation procedure, the Supreme Court reached the following conclusion. The law of Ukraine on private international law establishes judicial immunity regarding a foreign state in the absence of the consent of the competent authorities to the relevant state to involve it in participating in a case in a national court of another state. At the same time, European Convention of State Immunity adopted in 1972 and also United Nations Convention of Jurisdictional Immunity of States and their property adopted in 2004 provides that a state does not have the right to invoke immunity in cases related to causing damages to health or life if such damage has been caused in whole or in the part on the territory of the state of the court, and if the person who caused the damage was at that time on the territory of the state of the court. Actually, I must say that Ukraine is not a part of any of these conventions. However, they reflect a trend in international law development to recognize that there are certain limits within which a foreign state is entitled to claim immunity in civil proceedings. It is a well-known fact from facts that since 2014, the Russian Federation has been committed armed aggression against Ukraine. This was established in particular in recent judgment of the European Court of Human Rights of June 25, 2024 in case Ukraine versus Russia, Re Crimea. Also, in accordance with the resolution of Verkhovna Rada of Ukraine, its Ukrainian parliament on April 2024, the actions of the armed forces, political and military leadership of Russia during the armed aggression against Ukraine, which began on February 24, 2022, were recognized as genocide of the Ukrainian people. While determining whether the Russian Federation is subject to judicial immunity in this case, the Supreme Court took into consideration the following. First of all, the subject of the lawsuit is compensation for moral damage caused to individuals, citizens of Ukraine as a result of death of another citizen of Ukraine. The place of infliction of damage is the territory of sovereign state, I mean the territory of Ukraine. Damage caused by agents of Russian Federation who violated the principle and goals enshrined in the United Nations Charter regarding the prohibition of military aggression committed against another state. The commission of acts of armed aggression by a foreign state is not an exercise of its sovereign rights, but indicates a violation of the obligation to respect the sovereignty and territorial integrity of another state, Ukraine, which is enshrined in the United Nations Charter. According to the general rule established in the national legislation of Ukraine, damage caused in Ukraine to any individuals as a result of the illegal actions by any other person or entity may be compensated by judgment of Ukrainian court according to the principle, so-called principle of general delict. In other words, the Supreme Court proceeds from the fact that in case of application of the so-called tort exception, any dispute arising on its territory for a citizen of Ukraine, even with a foreign country, in particular the Russian Federation, may be considered and resolved by a court of Ukraine as a proper and authorized court. Therefore, after beginning the war in Ukraine in 2014, the Court of Ukraine, considering a case whether the Russian Federation is a defendant, has the right to ignore the immunity of this country and consider cases on compensation for damage caused to an individual as a result of the armed aggression of the Russian Federation. Besides, after the full-scale invasion of the Russian Federation in 2022, Ukraine severed diplomatic relations with Russia, which makes it impossible to send various requests and letters to the embassy of Russian Federation in Ukraine from the date due to the termination of its work on the territory of Ukraine. It is also impossible to send correspondence from Ukraine to Russia due to the suspension of postal services between the country. In the subsequent judgments, the Supreme Court gave additional arguments regarding for non-application of judicial immunity of the Russian Federation, which come down to the following. First of all, maintaining the judicial immunity of Russia will deprive the plaintiff of effective access to the courts to protect his or her rights, which is incompatible with the provision of Article 6 of the Convention for the protection of the human rights and fundamental freedoms, hereinafter referred to as the Convention. According to the European Court of Human Rights case law, the granting of immunity to a state and civil proceedings pursues the legitimate aim of observing international law to promote civility and good relations between states through respect for the sovereignty of another state. The application of judicial immunity of the Russian Federation in cases for damages must have a legitimate purpose, in particular the promotion of civility and good relations between states through the observance of international law. At the same time, Russia's armed aggression against Ukraine carried out in violation of the fundamental principles and norms of international law, in particular the United Nations Charter. International law crimes committed by its armed forces in Ukraine exclude, at the initiative of Russia, the issue of civility and good relations between countries. This defeats the legitimate purpose of applying the Russian Federation's judicial immunity, which limits the plaintiff's right to a fair trial. Hence, the plaintiff's appeal to Ukrainian court is only effective remedy, the deprivation of which would mean the deprivation of such a right altogether. In other words, it would deny the very essence of such a right. Also, the Supreme Court said that judicial immunity of the Russian Federation does not apply due to customary international law codified in the United Nations Convention on Judicial Jurisdictional Immunities of States and Their Properties 2004, and as stated in its judgment, the European Court of the Human Rights in case Alenika versus Russia. If national courts uphold the jurisdictional immunity of a state without any analysis of the applicable principles of customary international law, such courts violate the applicant's right to access to a court, even in those cases where jurisdictional immunity is applicable. So the Supreme Court noted that in the matter of the application of state immunity from jurisdiction, the relevant norms may not be interpreted abstractly or in isolation from the established factual circumstances of the case. The specifics and circumstances of each case, as well as underlying factors, must be fully taken into account. In this case, we are talking about claims on damages for wrongful actions committed by the Russian Federation in the absence of alternative means of damage compensation. And also maintaining the immunity of the Russian Federation is contrary to the international legal obligations of Ukraine in the field of combating terrorism, because Ukraine is a part of the Convention on Prevention of Terrorism, which was adopted by the Council of Europe in 2004. Also, Ukraine is a part of the International Convention for the Suppression of the Financing of Terrorism, and Ukraine is obliged to create a compensation mechanism for victims of terrorism-related crimes. Therefore, the application of the Russian Federation judicial immunity and refusal to consider the merits of the claim in this case would mean Ukraine's violation on its international obligations in accordance with the above-mentioned conventions on combating terrorism. Hence, we can make the conclusion that the Supreme Court emphasized that judicial immunity may not prevent citizens of Ukraine from the right to access the court in disputes related to compensation of damage caused by aggressor. Thus, the highest court in the judicial system of Ukraine removed the legal barrier in bringing the Russian Federation to liability for armed aggression against Ukraine and its citizens. At the same time, we can discuss the question about the right to access to the court and state immunity and the problem of the correlation between the right to the access to the court and the right to an effective remedy and the application of the immunity of the state must be covered in more detail. I must to say that application of immunity by the state is carried out on the basis of the norms of international law aimed at promoting good relations between states and avoiding interference with the sovereignty of another state. Modern international law leans in favor of the theory of functional or limited state immunity, according to which the principle of state immunity applies only to the state's activities that have a sovereign nature. It's called acta iure imperii, as opposed to activities not related to the state's performance of sovereign functions, for example, in the field of economic and trade relations, and it's called acta iure gestionis. At the same time, various violations of human rights arise from state actions committed outside of international trade and economic activity, and therefore are not the subject to the rule of state immunities acta iure gestionis. If we turn to the experience of European countries, then the Ferini case, which was considered by the Joint Chamber of the Italian Court of Cassation, is well known. The decision in this case was adopted in 2004, and in that period, the Italian courts issued a number of judgments on compensation by Germany to the plaintiffs, its victims of their heirs of war crimes and crimes against humanity committed during the Second World War. Italian courts noted that the rule of jurisdictional immunity of the state could not prevent victims of gross violations of human rights from realizing the protection of such rights. The Italian Court of Cassation, while considering this case, emphasized that deportation and forced labor are war crimes prohibited by the mandatory norm of general international law, jus cogens. If human rights violations are crimes against humanity and war crimes, they are violations of jus cogens, and therefore the rule of jurisdictional immunity must be excluded. Norms of jus cogens prevail over any other norm, whether customary or generally accepted, and hence they also prevail over the principle of sovereign immunity. Also, we can see the other approach, and opponents had argued that the claim of automatic superiority of jus cogens over state immunity is an irrelevant argument. State immunity is a procedural norm that belongs to the jurisdiction of national courts. It does not apply to substantive law. It does not contradict the prohibition contained in the norms of jus cogens, but only establish another way of dealing with any violation of this principle. Considerations regarding the application of judicial immunity can also be found in the case law of the United Kingdom. Thus, in the case upon a claim to English courts by victims of torture in Saudi Arabia with claims for damages, the House of Lords expressed a critical position on the judgment of the Ferini case, having noted that jus cogens prohibition of torture does not entail an exception to the rule of the jurisdictional immunity of the state. It's a well-known case of Jones, Mitchell, and others versus Saudi Arabia, decision 2006. Also, the International Court of Justice of the United Nations expressed its position on the judicial immunity of the state. At the end of 2008, after Germany was ordered by the Italian Court of Cassation to pay about 1 million euros to the families of 9 people killed by Nazis in town of Toscana in 1944. Germany appealed to the International Court of Justice of the United Nations with a claim against Italy, stating that since 2004 Italian courts repeatedly ignored the jurisdictional immunity of Germany as a sovereign state, thereby violating the norms of international law. The International Court of Justice of the United Nations, based on the results of the consideration of this case, recognized that the discussed facts of gross violations of human rights constituted serious violations of the norms and international humanitarian law. But at the same time, the court made the following conclusion. According to customary international law in its current format, the state is not deprived of immunity due to the fact that it is accused of serious violations of the norms of international law regarding the protection of human rights or international law regarding the settlement of armed conflicts. This conclusion is in decision in case of jurisdictional immunities of the states 2012. Also, the International Court of Justice of the United Nations provided its own reasoning on the connection between use organs and the rule of state immunity. So the norm of the law of armed conflicts, which prohibit the killing of civilians in the occupied territory, the deportation of civilians and prisoners of war, to force them into slave labor, are use organs rules. State immunity rules are procedural in nature and are limited to determining whether the courts of one state can exercise jurisdiction over another state. They do not address whether the conduct in question was lawful or unlawful. Hence, the International Court of Justice of the United Nations reached the following general conclusion: that the principle of jurisdictional immunity of the state remains valid and may not be subject to any exceptions regarding human rights. Currently, the next appeal of Germany against Italy in 2022 is pending before the International Court of Justice of the United Nations, because the courts of Italy continue to consider claims of victims of Nazi war crimes on the payments of compensation by Germany. After the judgment of the International Court of Justice of the United Nations of 2012, more than 25 compensation claims were filed in Italy, and in many cases Italian courts ruled that Germany should pay them. There were even attempts to seize real estate in Rome owned by Germany in order to enforce the judgments of Italian courts. For Ukraine, as a Council of Europe member, the issue of correlation of jurisdictional immunity of states with the right of access to court in accordance with Article 6.1 of Convention is important. I have to mention that the European Court of Human Rights, in its well-known case Al-Atsani versus the United Kingdom, expressed the view that the prohibition of torture is part of use organs. At the same time, the court noted that by granting jurisdictional immunity to Kuwait, English courts did not violate Article 6 of the Convention. This is justified by the fact that jurisdictional immunity is considered a limitation of the right of access to a court that pursue a legitimate goal. Its goal promoting goodwill and good relations between states. And such a limitation may not be considered disproportionate as it reflects a generally recognized norm of public international law. The judgment in this case, the case Al-Atsani versus the United Kingdom, was made in 2001. Later, the similar position was expressed by the European Court of Human Rights in the case Gross versus France 2009, and in the case Jones and others versus the United Kingdom, the court noted that there was no need to review such an approach and emphasized that the recently adopted judgment of the International Court of Justice of the United Nations in the case Germany versus Italy, which should be considered authoritative by the European Court of the Human Rights regarding to the content of customary international law, clearly established that by February 2012, no use organs exception to state immunity had yet been crystallized. Opposite consideration can also be given. Thus, according to the judges who expressed concurring opinion in the case Al-Atsani versus the United Kingdom, the confidentiality of a foreign state's immunity from the judicial jurisdiction in respect of civil claims arising out of torture is completely contrary to the nature of US slogans on prohibition of torture. And this rule loses any practical application. By the end of this lecture, I want to emphasize that one can agree with some scholars, for example, Dr. Francesco De Santis Di Nicola, who points out that the application of jurisdictional immunity of the state and the rejection of any exception to it regarding human rights can be lead to the fact that victims of war crimes or other gross violations of human rights will be deprived of the possibility to go to court and receive adequate compensation. It is obvious that the time has come to change approaches in international law to the discussed concept, as it has already happened at the beginning of the 19th century, when the absolute customary international law regarding the jurisdictional immunity of the state underwent a gradual evolution due to the development of national jurisprudence to the definition of acta iura gestionis. I am convinced that the national courts of Ukraine have a unique chance to contribute to the change in international legal approaches regarding the judicial immunity of the state by resolving a lawsuit related to the war in Ukraine unleashed by the Russian Federation. Thank you for your attention, and I also would like to express my deep gratitude to all European people, to all European countries for such comprehensive support of Ukraine during this war. Thank you very much.
Thank you. Thank you very much, Honorable Judge, Dr. Professor of Law, Vitaliy Urkevych, for such a fascinating talk on European Supreme Court's practice in cases related to the war in Ukraine. Now I'm going to open the session to question and answer. As announced previously in my various emails, that in order to ensure equal, diverse, inclusive, and safe environment, all attendees are requested to submit their questions in advance. In this regard, I received a couple of questions, and I'm going to read it out on their behalf. So the first question, which I received from some of the attendees, is a lot of internal displacement took place during the war in Ukraine. People close to Ukraine-Russia border were more affected than those living in other areas of Ukraine. How do you see the role of the Ukraine Supreme Court in protecting fundamental rights of people living close to Ukraine-Russia border and maintaining equality of all Ukrainians before the law?
It's a quite interesting question, and I must say to you that all the Ukrainian and Russia border, in fact, as a military zone, it's a zone of military front, and of course we have a lot of displaced people. Of course, the hostilities, they threatened the life of judges, of citizens, of parties, and other persons. And in Ukraine, we introduced some special mechanism. I mean that by the request of the head of the Supreme Court, the High Council of Justice can change the venue. I mean the territorial jurisdiction of the courts, which is near the front line, to the more safer parts of Ukraine. Also in Ukraine, we have a special electronic system. I mean, electronic court was introduced, and plaintiffs and defendants and other parties can use the functional of this court for sending claims, requests, and other things. A lot of court hearings is making with using of the video conference or video call. It's very helpful for us, and so in such way we guarantee the access to the justice to all citizens and other peoples who are in the territory of Ukraine.
Thank you for the answer. The next question I received from attendees is, do you think the Ukraine Supreme Court is currently independently behaving against other branches of the state and is able to hold other parts of the government accountable?
It's a very interesting question, and of course you understand that in Ukraine the principle of separation of powers has been implemented in the constitution of Ukraine and other legislation. And as you understand, the Supreme Court belongs to the judicial branch of the power. It's the highest body in the judiciary of Ukraine. And our legislation, we have a range of guarantees of independence of judges. I mean, now judges are appointed through the special contest. Also, judges have good financial support, good salary. Also, all judges are appointed for life tenure, and we have a prohibition about the prosecution of the judges for their judgments. Also, I can mention that as a part of the Supreme Court, the Cassation Administrative Court acts, and this court have a jurisdiction to hear the cases against highest state bodies. I mean, the President of Ukraine, the Parliament of Ukraine, the High Council of Justice, and these cases are heard by the Administrative Cassation Court as the court of the first instances. And actually, the Grand Chamber of the Supreme Court is the appellate instance in such cases, and for such cases there is no cassation proceedings in our legislation.
Thank you. Third question that I received from attendees is, how do you see public support for the Ukraine Supreme Court? Is that currently ideal, or do you think it needs some improvement?
It's a great question because, as you understand, we have some problems in this field and the fields of relations between the Supreme Court and the public, and we have such figures from the latest public opinion polls in 2023, and I must say that above 25% of public confidence in the Supreme Court and the entire judicial system. Of course, you can ask why it's so, why we have such figures. Maybe it's not big, but you must understand that quite often public have some misunderstanding of the functioning of the Supreme Court. Moreover, some media sometimes try to show only negative sides, negative aspects of functioning, and that is why Supreme Court now develops the SARA communication policy, and actually before this lecture we had a meeting, a special meeting of all judges of the Supreme Court. It's called the plenum of the Supreme Court, and we created a special group for developing a special communication strategy of the Supreme Court, because I understand that it's very important to inform society, to inform media, to inform public about works, about decisions of the Supreme Court. Moreover, our Supreme Court has an official pages in social media. For example, if you open page in Facebook, so we have the Supreme Court has above 60,000 followers. It's quite a good number, quite a big number, and we understand that it's a big media, rather big legal media.
Thank you. Last question that I have is, what main lessons do you think countries with conflict similar to the one going on in Ukraine should learn from the Supreme Court of Ukraine and its decisions?
Thank you for this lecture, and as you understand, as you can find out from the information from my presentation, military aggression poses significant challenges for the justice, and as for me, it's important that the Supreme Court and also the courts of the first and appellate system, appellate instances, they did not stop work in Ukraine. It's very important because every Ukrainian sees that it's the territory of Ukraine, the judicial system is functioning without any interruption. Of course, we must to stop hearing during a lot of array attacks. We have to go to shelters. We have a lot of problems with electricity supply because of rocket attacks, because of heat of our electricity, power stations, and so on and so forth. But the Supreme Court and the judicial system is working all the time of this war. Moreover, it's very important that we don't wait for the end of this war. We make legal positions which are in behalf of our citizens, with using of which plaintiffs can, for example, collect the damages or can remove the judicial immunity of the Russian Federation and other. From my presentation, you can understand what I mean. And I think that such approaches must be used by other countries who have military conflicts.
Thank you very much. With this question, we have come to the end of the session. I would like to say thanks to our today's guest speaker, Honorable Judge Doctor of Law, Professor Vitaliy Urkevych, Secretary of the Grand Chamber of the Supreme Court of Ukraine, for delivering the guest lecture during the Judges Guest Lecture series of the Global South Network. Thank you, Lina Huber, and other supporting staff of the Supreme Court of Ukraine for their support and smooth coordination. I personally enjoyed my coordination with them. I hope you also, have a best experience during this guest lecture series, and I'm looking forward to continued collaboration in the future. Thank you all attendees who had attended today's session. Before we say goodbye to each other, allow me to announce that our next guest lecture by the President of the UK Supreme Court, the Judicial Committee of the Privy Council, Robert Reid, Lord Reid of Bellarmire, during the network's Judges Guest Lecture series titled North and South Judicial Cooperation between the United Kingdom and the Global South, will take place on 20th of January 2025. Until then, look after yourself. Have a great day. Thank you very much. Bye.